And good afternoon. Welcome to today's edition of Ask a Lawyer on Facebook Live. I'm attorney Michael Bender.
And I'm attorney Tilton, and we are the Gray Legal Group.
All right, as always, we start off with the contents of this video is for general information purposes only. Nothing should be taken as legal advice for any individual case or situation. This information is not intended to create, and receipt or viewing does not constitute an attorney-client relationship. All right, we'll go ahead and start off with questions today. The first one deals with paternity judgments and at-home DNA testing. Will a judge vacate a paternity judgment after 3 years based on an at-home DNA test?
Oh, this one's for me to answer.
I guess I can go ahead and answer this.
I'd go ahead and answer it. Okay, so the way I'm looking at this question, there's a couple little questions in here. First off, if we have a paternity judgment, you've probably signed a stipulation and advisement and waiver of parental rights. You typically do that at court. Part of that form indicates to the court that you are saying that you are the parent. You are waiving all rights to DNA tests, to a trial on that issue, basically for the court to adjudicate whether or not you are the parent. So if we have a judgment, you've probably signed this waiver. Secondly, this is talking about something that occurred 3 years later. There is a very short window to try to set aside a judgment. That window is typically 6 months, and there's some pretty stringent criteria on setting aside any type of judgment. So the at-home DNA test, quite frankly, I don't think it makes a difference what kind of DNA test you've done, whether it's at home, at a lab. It's just not going to make a difference. So I'd be in the opinion that no, a judge will not vacate a paternity judgment after 3 years.
Now, a little underlying context with regards to this question is the explanation indicated the one who took the DNA test was the one paying child support and wanted a child support case to be closed. As Allison indicated in the signing of the advisement and waiver of rights form that you typically will sign when the judge basically says, "Are you mom, are you dad?" That indicates an acknowledgement that you understand you have the financial responsibility to provide for that child up until they reach the age of 18 and other things we'll get to in a minute. And ultimately that 3 years is going to be very troublesome here. There are certain provisions of the Family Code that allow set-asides of judgment for up to 2 years, but very difficult to obtain. So my answer to that question would actually, in fact, be likely not. Next question. My daughter turned 18 18 years old a few months ago and is now attending college. Her father's wages are still being garnished for child support because he never had it stopped. Am I responsible to pay the money back?
Quick answer, yes. You are responsible to pay the money back. Basically, child support obligations, they terminate as a matter of law. Nobody needs to go back into court to get a termination of child support. It's going to terminate as soon as your child reaches 18 and is no longer enrolled as a full-time high school student, age 19 or emancipated. So if your child has graduated high school and is 18 years old, child support ends. You actually, as the recipient of child support, are more likely to have the obligation. Actually, you do have the obligation to stop that garnishment. If you're garnishing through the Department of Child Support Services, I would give the Department of Child Support Services a call, let them know, hey, my child's turning 18 and graduated, so that they can stop that garnishment for you. Or if you have an income withholding order through the courts, you need to file for a modification of that withholding order. Anything else?
I think that about covers all of that. Additionally, in the rare circumstances, if child support is being paid not through a wage garnishment, yet checks are still being drawn or a transfer, bank transfer is being done. Once that child reaches those provisions, absent any other agreement, child support does stop, and you are not entitled to receive that money anymore. So, with that, we want to thank you for joining us today on Ask a Lawyer. Join us each week as we discuss family law issues important to our community. If you have a legal question or topic you'd like us to address, go to thegreatlegalgroup.com and click on Ask a Lawyer. We'll see you next week, Tuesday at 1:30.